Welcome to the Unique Bilingual State Podcast, a podcast recorded by Defining Moments Canada in the context of the Unique Bilingual State Project, which explores 250 years of institutional French-English bilingualism in all of its evolving complexity, from the Quebec Act to the present day, within the broader context of language use in Canada. Each English language episode is hosted by Anna Goldsworthy, Director of Programming and Curation at Defining Moments Canada, and features conversations with Serge Dupuis, a Franco-Ontarian historian, author of 3 books and over 30 articles that mostly deal with Francophone communities in Canada. In this third episode, Anna and Serge discuss the fight for French language school management.
Thank you, Serge, for once again joining us to talk about French-English bilingualism in practice and in play throughout Canada. And thank you to our listeners for also joining us to explore more about this topic as part of the Defining Moments Canada project, a unique bilingual state, 250 years of bilingualism in Canada. Now, in the first 2 episodes of this podcast, we learned or expanded our knowledge on Regulation 17 and the fight for French Ontario high schools. And these 2 topics segue very beautifully into today's topic, which is more of a national scope, and that looks at the fight for French language school management. Before we get into the history and the story behind this topic, however, I think it might be helpful to first unpack what we mean by school management. So Serge, if you could, would you mind explaining what you're referring to in using the term school management?
For sure. As common or grammar schools were established in Upper and Lower Canada at the turn of the 19th century, they were often governed by parents and taxpayers, and they were governed locally. Often you had a single school that was managed by a board of local parents and taxpayers, because most of the funding to administer those schools was raised locally through school property taxes. There were provincial grants that eventually did come, but even by the time Regulation 17 came around in the 1910s, it only accounted for about 1/3 of school funding, which meant that communities funded their education, and therefore they had a responsibility to administer the management of those funds. And schools, as we talked about in the first episode, also tended to reflect local values, religious values, the local culture, and the local language, which meant that you had a variety of schools that were either public or separate in Ontario. But you had hundreds, if not a few thousand, school boards in the 19th century. And as time progressed, the province tended to amalgamate them and produce regional boards, and eventually county boards, and eventually, at least for the French language component, boards that were province-wide or that covered a large part of the provincial territory. So the number has progressively gone down, and some provinces have abolished school boards, such as Nova Scotia and Newfoundland, and even Quebec. But they've abolished majority language school boards because there exists today a constitutional right to minority official language school boards. So while there's no English language board in Newfoundland or Nova Scotia, and no French language board in Quebec, there are Anglo-Quebecer school boards and Acadian school boards in Nova Scotia and Newfoundland.
I think oftentimes people kind of think that the French language institutions around education were always there and always inherent, in the rights to protect French language education was always just kind of a thing, which is obviously not the case. And with that in mind, I was wondering if maybe you could explain the impact that some of these old major legislations, like the Constitution of Canada and the Charter of Rights and Freedoms, had on these communities and had on French communities. You had mentioned, obviously, some of the inherent rights, but if you could expand more on that.
So the Constitution of 1867 recognized existing school rights, which meant that religious schooling rights were protected for Protestants in Quebec that were also Anglophone, and therefore it tended to protect both. Whereas in Ontario it was a bit more complicated because the separate boards were Catholic, but you had a linguistic division between Irish Catholics and French Canadian Catholics, who were the predominant groups of Catholics up until the middle of the 20th century. So there were no provisions really for French language school boards. What you did have, though, were boards where Francophones were a majority. And as we saw in episode 2, that meant that in areas where French Canadian trustees were the majority, they tended to resist Regulation 17 or schooling regulations that prohibited the teaching of French in publicly funded schools. So they used the democratic tool that they had access to to govern themselves in a certain way, even if there were no officially uniquely French language boards. With school board management across the country, it tended to go in diverging directions. So in the prairies, for example, you did have majority French language boards, bilingual boards, when they were small and rural. But with the amalgamations that happened after World War II, they tended to be anglicized and find themselves in a small minority within larger school boards. In other areas like Prince Edward Island or Nova Scotia, some regional boards that emerged remained majority French speaking. So in Western PEI and in southwestern Nova Scotia, where you have large Francophone populations. Again, they were officially bilingual boards, but Acadians had the majority. The only province other than Quebec to have linguistic school boards prior to 1982 was probably New Brunswick, that had begun developing a certain administrative duality within the Ministry of Education in the 1960s and a complete distinction in 1974 with ultimately what was two parallel ministries of education. You also had the regional school boards in the northern Acadian counties that were recognized as French language, but that happened almost as a coincidence because they were in largely homogenous territories. So by 1980, when the act recognizing the equality of two official linguistic communities in New Brunswick came into effect, they adopted two linguistic school district maps, and that was a first in Canada. It was also more a clearer linguistic division than you had in Quebec, where yes, you did have Protestant boards, but that had become more bilingual with time with Francophones that were unsatisfied with the Catholic boards. So New Brunswick made that transition between 1971 and 1980. They had separate French language and English language boards across the province by 1980, and it was pretty much the only province that had that. When the Trudeau government began elaborating the Canadian Charter of Rights and Freedoms, they wanted to guarantee access to minority language education. The idea was to protect English language education to those who had a historical right to that education in Quebec, and also to develop French language education, not so much in New Brunswick and in Ontario, where it tended to be quite widespread, but in the other provinces where often you didn't even have a school that was, or a class that was distinct from French immersion, for example, or schools were still bilingual or English speaking uniquely. So the charter sought to create a certain equality amongst minority language schools, even if it didn't explicitly talk about distinct linguistic school management.
Okay, so now that we've kind of received some of the backdrop on some of the historical makeup of this early legislation around the Constitution Act, I wonder if you could explain to us exactly what is Article 23, which you had mentioned in the last question, and does this article and does the Charter of Rights and Freedoms override those earlier legislations?
So the charter that came into effect in April 1982 had Section 23, which guarantees citizens whose first language learned and still understood, and who have received their primary school education in Canada in English or French, that those people have the right to educate, to have their children educated in that language, where the numbers of such children so warrants. It also meant that parents had the right to have their children educated in quote unquote minority language educational facilities provided out of public funds. So minority language educational facilities. The word facilities in French is établissement. It doesn't have exactly the same meaning in French and in English. Facilities could mean building for an Anglophone. Établissement means institution in French. So if it's a établissement de la minorité linguistique, the article there, the preposition de, emphasizes a sense of belonging to a community. It does not explicitly say a French language school board. It just says that it's a facility that belongs to the community. In the French version, it's not as clear in the English version, but in the interpretation of these sections by courts, the version in either official language is equally important. So there was that door that was kind of opened to the idea of management. To answer your second question about overriding what was in the Constitution of 1867, we talked about in the first episode the fact that Section 93 guaranteed the right to separate schools for the Christian minority, Protestant in Quebec, Catholic in Ontario. It did not protect separate schools in New Brunswick or other provinces, which explains why publicly funded religious schooling was abolished in a lot of cases in the 19th century. So it kind of complicated things in Ontario in a way because the government wanted to avoid creating 4 types of school boards, which they ultimately had to do a few years later, but they already had 2 types of school boards for the entire province. They were even hesitant to create a 3rd type. And even when Section 23 came into effect, the Attorney General, Roy McMurtry, actually referred the Ontario Education Act to the Court of Appeal to verify its constitutionality, to see, well, what type and what degree of control and management would be given to parents and to communities. And did that mean a distinct linguistic school board? And how many pupils did you need to have a French language classroom or school? And ultimately, the court in June 1984 said, yes, your Education Act is not terrible, but it does need to be reviewed because your definition of Francophone child is a bit too restrictive in comparison to the new Section 23 of the Charter. And the fact that school management by Anglophone majorities had often been used to slow down or block the construction of French language schools, which meant that you probably needed to grant a greater degree of management and control to Francophone parents and communities. That in effect, minority facilities were, and this is the court said it was part and parcel of the minorities' social and cultural fabric, which meant that the facility belonged to the community. But again, they weren't saying that they needed a French language school board. So what they did in 1985, 1986 is develop French language sections within existing boards, which meant that Francophone trustees had the jurisdiction to manage the construction of schools, hire staff, and administer the school program. But they did not have exclusive management, for example, of school transportation, budgets, and the management of premises, which was kind of co-managed with the Anglophone trustees. So it was kind of like a step towards school management, but these were not yet French language school boards. But that was the attitude of the progressive conservative government that was defeated in 1985. The Liberals of David Peterson went ahead and created actually, I think, something that only existed once in Ontario's history, which was a mixed public and Catholic school board of French language schools for the Ottawa-Carleton regional municipality. And that existed from 1988 to 1994. In the meantime, they also created two other boards to manage Catholic French language schools in Prescott-Russell counties and the French language public schools in what we called Metropolitan Toronto in those days. So French language school boards were slowly established as pilot projects in Ontario, even if most French language schools were managed by these French language sections within the existing Catholic and public school boards.
It's interesting that you refer to it as a pilot project. It's not a way that I had originally kind of viewed the expansion of French language school boards in Canada. I don't think a lot of people associate it that way, especially when, a lot of people will think of French language schools and they'll think of a very Ontario-centric or a very Quebec-centric view on them. So I kind of makes me wonder. We've explored the starting points of French schools and French school boards and the evolution of how these schools are managed through the protections of various legislation, national legislation. I say protections and with air quotes, which the people on the podcast can't see, but especially lately, we're seeing these legislations and these various French language protection laws come into discussion and be kind of dissected or evolved or expanded on. So I wonder if you could go into some of the challenges that French communities face in trying to adhere to these laws or try to fight against certain restrictions regarding French language schools, especially those schools outside of Ontario and those schools outside of Quebec.
Right. So you did have the logic of community management of these schools was very advanced in New Brunswick. It was already there by the time the charter had come about. And in Ontario, you had advisory boards for French language high schools, and you had these separate boards where Franco-Ontarians were the majority. So there was also that nuance that still existed. So the charter brought French language sections to public and Catholic boards, and they brought about the first French boards that existed in certain regions. In other areas, parents did use Section 23 to say that bilingual schools, whether in Newfoundland or in British Columbia, were insufficient, that they did not correspond to the right to French language education for the elementary and secondary levels. And often they had to threaten a legal challenge to the province in order to open the first French language schools, for example, in Newfoundland in 1988 and 1999, or 1988, yes, and 1989. In the Northwest Territories, they opened the first French language school in Yellowknife in 1989, in Whitehorse in 92. So it did bring about progress through persuasion, through the canals of regular politics, but it tended to be quite uneven still. And the example that comes to mind, of course, is that of the group of Edmonton parents led by Jean-Claude Mahé and Angeline Martel, who set up a full French language school in 1983, inspired by the provisions of Section 23. And they convinced the Edmonton separate board to fund the school during its second year of existence. But the province intervened and said that they did not want to fund a full French language program, that they did not want to separate the funding it got for French immersion from full French language education. So they set up a charter challenge with the funding of the Court Challenges program that was set up by the federal government in 1978. And they sought to demonstrate that the Alberta Education Act was not respecting Section 23. And there were different rulings. The Court of Appeal said that the number of ayants droit or rights earners, I'm not trying to translate that, were sufficient to justify the existence of a homogenous French school. but that the thresholds had not been defined for community management. So the Supreme Court of Canada actually took up the case. And in March 1990, they said that there was a remedial nature in Section 23, that French schools were essential to the development of the two official languages and cultures, and that the expression minority language educational facilities did indicate that the schools belonged to the minority, and that these were probably, that we probably needed a degree of management and control because there was a certain inaction of public authorities in developing the separate school regime. They also said that there were probably enough parents in Edmonton to reach the higher criteria of the possible range of requirements, but they did not explicitly say either that you needed a French language school board. So it was actually another court challenge from Manitoba parents that had already begun at the same time, where the provincial court of appeal had said that it was up to the province to determine the degree of control and management by Franco-Manitoban parents. And then the Société Franco-Manitobaine kind of said, well, the Maillet decision and the decision by the provincial court were in contradiction, and therefore the Supreme Court needed to come back on the issue, which they did in 1993. And then they ultimately said, well, if we look at this judgment that we had said, the 3,000 students, French language students in Edmonton, were probably sufficient for a French language school board. So there's more than 3,000 in Manitoba. So let's just say it that, it's justified that we establish a French language board in Manitoba. And what's good for the goose is good for the gander. If it's good for Franco-Manitoban parents, then it should be applied to the entire country, which brought about ultimately between 1993 and 2001 the emergence of at least one French language school board in each province and territory. There are a few exceptions. So New Brunswick had 6, Ontario had 12, and Alberta had 3. I use the past tense there because today New Brunswick has 3 and Alberta has 4. So they actually had one mixed board split up in 2003. But yeah, within 8 years and some federal funding in order to establish these new boards, the reference on the Manitoba Education Act brought about the kind of forced establishment of French language boards in the provinces that didn't have any, which was most provinces and territories, except Ontario and New Brunswick.
What I find very interesting about the discussion in terms of setting up French school boards outside of Ontario and outside of Quebec is I think a lot of people underestimate the amount of French communities in these other provinces. And I find it especially interesting today with our modern understanding of languages in Canada and language use in Canada, especially with the backdrop and consideration of Indigenous languages. Trying to set up, I imagine, French school boards in the territories would have been immensely difficult, especially if anyone is trying to keep in mind Indigenous languages there and early Inuit languages. So it's kind of an interesting thought on the evolution of school boards, and even as you're mentioning, they split up or they merge or they add or they take away, and it'll be interesting to see how these school boards adapt with the years to come. So I guess that leaves us with a final question. How does this all work and look today? Where are we as a nation in relation to the supports and legal protections for French language schools and their management today, would you say?
Right. So there have been more court challenges in the 2000s and 2010s to kind of test out what this principle of equality comes out to. And there have been a few tests from looking at the discretionary power of the Minister of Education. Can a Minister of Education cancel the construction of a school, for example, in Summerside, PEI? And the court ultimately deemed that it couldn't, that the minister couldn't intervene, that it was up to the French language school board to determine what its needs and obligations were in accordance with Section 23. In Nova Scotia, there was another court case that went up to the Supreme Court in 2003 about the delays in the construction of schools, so that schools are promised, but that funding wasn't provided in a timely fashion. And in that case, the Justice Arthur Leblanc had actually asked the province to report back to him on the progress that had been made during, and it's the province that actually brought the case to the Supreme Court, saying that they shouldn't be required to be surveyed by the by a judge. And the court was actually pretty split on that issue. But 5 out of 4 judges kind of said, well, this was, respecting the spirit of Section 24 of the Charter that allows judges to be creative in demanding remedies for infringements on constitutional rights. So to avoid parents having to go to court again and again, you needed to offer a certain degree of authority to Francophone parents to establish the schools they thought they needed to have. And finally, there have been 2 court cases to come out of British Columbia that began in 2010 and ended in 2020. But about and it began for the École Rose des Vents. That was a terrible facility. It was an old, a kind of abandoned English language school that was, it was saturated. It was windowless in many places. There was lice infestations. There were long bus rides. And the argument was that this was not equality, that if you compared it to other local schools in West Vancouver, that this did not look like an equitable education. And the Supreme Court actually didn't necessarily rule. They said on its face, the building is not of equal quality, but we're not sure that Section 23 of the Charter has been breached. So it was actually a second case that involved, in that case, all of the French language schools in British Columbia that ultimately brought a decision about the point of comparison. What do you compare the quality of the French language school to? Should it be to the local school that's a larger establishment, or should it be to the smaller English language schools elsewhere in the province, and therefore that you had to be globally equitable? And that's pretty much what the judges decided in June 2010, that the point of comparison needed to be made with similar sized English language schools in the province. And that was how they defined substantive equality. And the idea is that you wanted to avoid that a reasonable parent be placed in front of a dilemma where you had to choose between a poor quality French language education and a higher quality English language education, that you needed to have certain aspects to that school that offset the fact that it was smaller or further, which meant that you probably needed to have a nicer building or extracurricular activities or advantages on class sizes. But you needed, even if you were offering something that was different, it needed to be equitable so that it was not seen as a dilemma or a sacrifice to send your child to French language school, because it was seen as this inequity was seen as a way to historically to contribute to the assimilation of younger generations by the fact that they were not providing an equal quality education. So actually the ramifications of the June 2020 decision, which applies to the entire country, haven't all come into effect yet. It will probably bring about a certain evaluation of the entire school system, and to evaluate, well, how many high schools have pools or football fields in Toronto, how many French language schools have that. And in order to be equitable, they probably will have to transfer some schools if they want to avoid building many new installations, because in a lot of cases, when Francophones obtain their school, as it was the case in Sturgeon Falls, right, the Anglophones got a new building and the Francophones got the older school. That wasn't always the case, but there were enough cases like that to get to a point where you have inferior quality infrastructure in certain areas. So the judgment of June 2020 is supposed to fix that over the next few years. And maybe attain an actual equitable dualist education system across the country.
I like the optimism, and I'm going to keep my fingers crossed and hope we get to a point where everything's nice and level. The idea of English students giving French students their hand-me-down schools, I don't think sits very well with me, especially even as an Anglophone, but I did do French immersion, and it was in Toronto, and French immersion in Toronto was very highly sought after. So those were usually in a nicer school, but there weren't very many of them. So
and in the Ontario case, we have to remember, right, that almost all French language schools were separate schools, and separate schools by definition were disadvantaged for their access to the commercial tax base up until 1997, which means that 2 centuries of schools were built with more funds for the public system, and therefore, because the French were almost all in the separate system, there has been some catching up since the tax system has been equitable, and threats of court challenges too have brought about funding to build new schools or additions or to modernize certain buildings. But the June 2020 decision kind of obliges provinces to take a look at the ensemble and to evaluate if globally it is today equitable or if it isn't. And there's probably still some catching up to do in certain areas, even if the issue has been at the top of the preoccupations at the Ministry of Education, for example, in Ontario for 25 years. So it's unequal. So in BC, if this is a new issue, well, in other provinces, it's been a preoccupation since the late 20th century. So the catching up is uneven. The catching up that has to be done is uneven from one region or one province to the other.
So you've really helped us to get a sense of how legislation in regards to French school management is playing out or was playing out province to province and into the territories. So I thank you very much, Serge, for sharing this history with us and giving us the story of French language education at a national scope. Next time we chat, we will be going back to the provincial level and exploring New Brunswick and their defining history with regards to bilingualism in Canada. Thank you, Serge, and until next time.
Thank you.
Thank you, Anna and Serge, for this discussion on the fight for French language school management. If you found this episode interesting, make sure to check out the other episodes of this podcast series, the adjoining articles, and all other resources created in the context of the Unique Bilingual State Project on Defining Moment Canada's website.